So hopefully you can all see that the front page of my presentation there. Fact-find hearings in private law proceedings. Where are we now? Well, you will all know the Children Act section 1 subsection 2a says there is a presumption that any parent should be involved in the life of their child if it furthers the child's welfare. And section 1 subsection 6 makes it really clear that if a parent is to be involved in a child's life, it is to be in a way that does not put the child at risk of suffering harm. And that is really the legal status on which we have the possibility of fact-find hearings, whereby allegations are made of a potential risk of significant harm, and the court needs to look at that evidence to determine whether or not that fulfills the criteria in welfare decisions being made for the child. So you'll all be familiar with the recent evolution of the case law, if I can put it like that. In January 2021, the Court of Appeal, of course, heard the conjoined hearings. 4 cases were conjoined in ReHN and others. I've put the reference on the screen for you. And that case essentially provided guidance on 3 key topics as I see it. The first being, when should there be a fact-find hearing? Note, it's not an absolute that there will be a fact-find hearing, and I shall go into that in more detail in a moment. Use of Scott schedules, everyone wonders whether we're still using on them or not, and I will deal with that too. And then, of course, the approach to coercive and controlling behaviour and how we deal with that in terms of pleading it, so making those allegations, responding to them, and indeed the court assessing that evidence and potentially making findings. Then, in terms of the evolution of case law, we have the case of K&K, Sir Geoffrey Voss with the lead judgment. I've popped the reference up there. If you have not read this case yet, it is absolutely essential that you do so. It provides really clear guidance as to the approach the court will take in terms of fact-find hearings. And again, I'm going to establish that further for you shortly. It's also really helpful to be aware of the approach from the judiciary in respect of these cases. And so the guidance from the President was issued for the Family Division on the 5th of May last year. That is available. You can simply Google it and you will get a flavour of the approach that your judge will be taking when faced with determining these matters. And of course, Practice Direction 12J is still at the core of proceedings and decision-making by the court. So where does that framework leave us in terms of private law proceedings now? The court is required at all stages, so it must keep under review the issue of domestic abuse when it's being raised. As practitioners, we have a duty to flag this to the court at the very earliest opportunity so that the case management of your proceedings can be properly tailored to meet the needs of the parties and indeed ensure limited delay for the children above all else. So in that regard, if you have a client who has shared with you concerns in respect of domestic abuse or risk of harm, it's vital that this is contained within the application form, within the C1A form, and indeed if you are the respondent to such allegations, that you complete the document within the form where it says response to allegations. So often that document is left blank, but the court will be looking for that now and wondering why there is no response to it by way of the formality if it doesn't feature. But just because someone is raising an allegation does not now mean that it will be determined by the court. And our clients need their expectations managed, quite frankly. The court will not simply try allegations because they are made. There is a different and now very robust approach that is being taken in private law proceedings as to whether a fact find is necessary, proportionate, relevant, and its purpose. And I shall unpick those further for you. But it's really important that we establish the nature of the allegations that are going to be considered. And we need to consider when, if proven and taken at their highest, the allegations would go to safeguarding in general, or in particular circumstances relating to contact or indeed living arrangements. So if, for example, the date of the allegations is after there has been extensive overnight or unsupervised contact, and broadly speaking, that has been a positive experience. So there are no new or recent allegations, if I can put it, but allegations are being made as to historical concerns. The court will look very, very carefully at whether or not it is necessary to determine those allegations, because for the children, the circumstances and impact on their welfare may well have moved on significantly. And the turning of attention to historic allegations may not be necessary in order to resolve the welfare decisions for the court justly, or indeed proportionately for the children. Unfortunately, the court has lent itself over time to parents becoming more entrenched in their positions. I find the making of the allegations requires a response, of course, and then we enter this spiraling of size of case, paperwork, evidence and the like, whereby the person making allegations wants to prove each and every allegation because they strenuously believe that that will impact on the decision, or there is some sense of justice that needs to be secured in respect of their treatment or the treatment of others. And indeed, those on the responding end to the allegations want to clear their name or have their day in court to prove that the allegations are completely unfounded. And the focus, unfortunately, for the parents then becomes on the allegations, the crux of those, establishing where the truth lies, as it were. And the distraction then is from the needs of the children, and focus tends to be on the real hostility, frankly, towards one another. So it's helpful at this juncture, I say, to share the words of Sir Geoffrey Voss from K&K. It's paragraph 67 that I've selected. And he said, "It seems that a misunderstanding of the court's role has developed. There's a perception that the Court of Appeal has somehow made it a requirement that in every case in which allegations of domestic abuse are made, it is incumbent upon the court to undertake fact-finding, involving a detailed analysis of each specific allegation made. That is not the case. As HN explained, and we reiterate here, the duty on the court is limited to determining only those factual matters which are likely to be relevant to deciding whether to make a child arrangements order, and if so, in what terms." And you heard my emphasis on those words because they play out through time and time again now in terms of the decision-making process for the court. So just because allegations are made does not mean a fact-find hearing is required. The ultimate decision is for the court, not whether your client wants a fact-find hearing or doesn't want a fact-find hearing, or indeed whether CAFCAS are recommending there be a fact-find hearing, or the safeguarding letter insists there is a fact-find hearing before any welfare advice can be given to the court. Whilst the court is required to take all of those views and standpoints into account, the ultimate decision and the one that will be taken is by the court. The family court is shifting away from being an arena for litigation of allegations between parents. Almost every relationship that appears before the courts, unfortunately, has had instances of bad behaviour by one or other or both parents. We can only determine those allegations where they are going to be relevant to the welfare and outcome decision. Now, clients make allegations to us repeatedly, and we have to consider whether those fall within different categories. And I'll come to the case law of B&B in a moment, but it may be said that it's easier to identify physical violence by way of domestic abuse and specify that as an allegation in terms of a date, an event, the evidence. We also have now to pay particular attention to allegations of controlling and coercive behaviour. And that's why I've included the definitions on screen. You will be receiving a copy of these notes in due course from our team at 3 Paper Building. But these are the definitions lifted out of the Domestic Abuse Act, section 2021. And we have the definition for domestic abuse, and then we have for coercive behaviour and controlling behaviour. And these, in my view, need close attention, because it is often the case that the phrase coercive and controlling behaviour is rolled off of the tongue by many. It's also the exact wording that features in a C1A form, for example, without further specifics particularly. And you'll see that the court requires those. So, and they're different. They can both occur, of course, but they may be one or the other in certain circumstances. So coercive behaviour is an act or pattern of acts of assaults, threats, humiliation, intimidation, or other abuse that is used to harm, punish, or indeed frighten a victim. So we need that intention there as well. And then controlling behaviour, you'll see, is an act or pattern of acts again, but it's designed to make a person subordinate or dependent, isolating them from sources of support, for example, and resistance and escape, and regulating everyday behaviour. So when your clients are giving you details as to their lived experiences and the allegations that they consider are relevant, you need to be identifying whether these are coercive behaviour or controlling behaviour, or both, or none. The court is being clear in terms of the requirement on practitioners to only put forward allegations that meet those definitions. So as in Re-L, a 2017 case, which was re-endorsed in H&N, it is said that not all directive, assertive, stubborn, or indeed selfish behaviour will be abuse in the context of proceedings concerning the welfare of a child. Much turns on the intention of the perpetrator, as I said a moment ago, and the harmful impact of that behaviour. So when completing those allegations that are being made in a formal written document, we need specificity in terms of the allegation itself, the intention and the impact. And it's really important that those building blocks are there. But by drawing that to your attention, I certainly do not for a moment seek to minimise the impact of domestic abuse and make it absolutely plain that it is grave. It has significant and long-lasting consequences for the person who is exposed to it, but also to the children who experience it, because they are victims of said abuse simply by being related to either party. So a lot of people have been asking about Scott schedules and whether or not we need them, particularly when allegations of coercive and controlling behaviour are made. And you've heard me just say the importance of specificity to assist the court. And that I've seen Scott schedules, for example, or C1A forms that simply read controlling and coercive behaviour 1999 to 2005, for example. Now, the case law has said Scott schedules may not be required, and instead a narrative statement as to the nature of allegations is of assistance. And that's the case of Re-JK. Scott schedules have not disappeared. I think it's far from that. The nature of them and the content has changed, however, in as much as the guidance from the case of Re-JK, as I've just referenced, and also I've added to your notes the case of AA and BB, both of which are well worth a read, are very clear that the court has to take a broad brush approach in considering the allegations so that it can establish whether a pattern of behaviour is in existence within the relationship and whether that amounts to abusive behaviour. indeed whether that is sufficient to impact on a welfare decision being made in respect of the children. So in Re JK, it was said that it would be very helpful to have had, in addition to the witness evidence, concise statements from each party, including a summary of the nature of the relationship, a list of the forms of domestic abuse, a list of key specific incidents said to be probative of a pattern of coercive or controlling behaviour, and a list of any other specific incidents so serious that they justified determination, irrespective of any alleged pattern of that coercive and or controlling behaviour. And then, rather than having a response to the allegations, as it were, they were saying it would be helpful in that narrative statement, or in a narrative statement in response, to know whether those allegations were admitted or indeed disputed. But formal responses were thought not to be necessary in the case of Re JK. In Re BB, I've referenced, it's Mr. Justice Cobb, who gives a judgment and is really clear about the use of clustering the evidence. So in terms of having a group of allegations relating to physical harm, for example, and then a separate group of allegations relating to, for example, emotional abuse, and then another example of financial abuse, and so on, as is relevant in your case, of course. And so that was the approach, rather than chronologically scheduling each and every allegation, for example, perhaps containing those within a Scott schedule style format, but under the heading physical abuse XYZ, emotional abuse ABC, financial abuse HJK, for example. I've referenced the case of Treharne and Lynn. As I've said now, it is a broad, holistic consideration of the evidence that will be undertaken by the court, rather than minutiae detail about each and every individual allegation. That doesn't mean the detail is not required, it is, but it is the approach of the court that is adjusted. Now, in preparing for those documents that are being required now, I've put onto the slides a link to Kafka's website, which has a fantastic tool, in my opinion, which is basically a tick box that they provide. If you just click on the link, it's available to you, and you can go through, and there is a list for each type of abuse that could be alleged, and examples, and whether or not those amount to and establish an allegation of controlling coercive behaviour, for example. So I've put on the slide there the headings, which I've given by way of examples of clusters that you would use. And then underneath there are some examples which I've lifted straight from that Kafka's tool to give you some context and some support around what might amount to an allegation that the court needs to consider as to whether it's going to have a fact-find hearing or not. Now, I'm conscious of time, so the next slide is about allegations of sexual abuse. Headlines: definitely read this case, A and another, and B and others. Mrs. Justice Knowles, she's the lead domestic violence judge. She gives some really clear guidance about allegations of sexual abuse. So if you have a case of that nature, then absolutely give this your attention, please. Headlines were that if you are adducing or want to adduce evidence of previous sexual behaviour with someone other than the party to proceedings, you need permission, you need to make an application. And indeed, if you are applying to admit intimate images, you need to make an application to the court before those are shared or indeed filed. And of course, she says that there needs to be a schedule of allegations proven, if proven, in accordance with Practice Direction 12J, paragraph 29. And so again, that would be a spot schedule format, effectively, detailing the allegations as found. So I've given you a bit of background and a bit of context in terms of Scott schedules and what we're looking for when allegations are being made in terms of reaching the threshold to make the allegation. But there is a new robust approach that is being taken by the courts, and you may well have experienced it already. There may have been some resistance by the judiciary to providing the opportunity for a fact-find hearing. And that is because the focus has shifted, and the court has to be satisfied of 4 key principles now when allowing a fact-find hearing to go ahead. Those 4 key principles are these. What is the purpose of the fact-find hearing? The purpose is risk assessment, okay, as to future child arrangements. So in terms of purpose, the court needs to know the nature of the allegations and how, if proven, that impacts on child arrangements. So the court will be unpicking the allegations, perhaps before the bulk of evidence is even filed, to look at the purpose behind the fact-find hearing and what resulting impact it has. Relevance. The court has to be satisfied that the allegation being made is relevant to the welfare determination. So it's not simply that they've been vile to each other, okay, which often happens. It is whether those incidents impact the children, have impacted the children, or will impact the children moving forwards, and how those could be managed. If they can be suitably managed, for example, by there being supervision in place, we don't need a fact-find hearing to unpick the allegations. Proportionality. The court has to restrict the allegations it's going to determine. It will feature 20, 25 plus allegations with responses, with counter allegations. The court simply doesn't have the resources to deal with that. So it is going to be shrinking those down to key issues. Remember, though, if there is a pattern of behaviour that needs to be established, then there needs to be sufficient allegations to establish that pattern. And whether it is necessary. So, of course, if there are admissions, if there are convictions, a fact find is not necessary. More importantly, perhaps, or less obviously, is if some allegations are admitted and some are not. Those that are not, do they take the case further in terms of risk assessing outcome for these children? And if not, it's unlikely the court will pursue a fact-find hearing in relation to those, because again, it all links back to relevance, purpose, proportionality, and the necessary. And it's really important that your client is aware of these features before going before the judge, because they will receive a robust response likely now. And so that puts the client at ease when they're hearing words that they're recognizing in terms of the test the court is making and applying, and also manages expectations. So if the court determines that a fact find is not necessary, you'll want the order to record the reasons why. If it is necessary, then of course you want to clarify those parameters. Which allegations are being determined? What evidence is being permitted to be gathered, if any, to corroborate? Police, medical, school records, third parties. Only going to be allowing third-party witness statements if they are absolutely relevant to an incident, not simply character references, as it were, that we often see. And our clients can secure police disclosure and medical disclosure themselves. They have a right to that material themselves if it is about them. So we don't necessarily have to be waiting for the court to direct those. We need to front load our preparation in these cases. So the court, when considering at an early stage whether a fact find is necessary, has more helpful material available to it in order to make that determination. Participation directions are a duty of the court to determine ultimately, and also to flag, but it is encouraged that practitioners are drawing to the attention of the courts whether any participation directions are required. These are special measures, whether there needs to be a ground rules hearing, screens, separate rooms, and even if no one is seeking a participation direction, record that on the order. Then we know, whoever is picking up the case, be it different counsel, solicitor, representative, advocate by way of support for a party, or judiciary, can see that that has been dealt with. Hot topic at the moment is cross-examination by QLRs, qualified legal representatives. I don't have time to go into the ins and outs of this, but just to flag and draw it to your attention if you're not already aware. Since the 21st of July of last year, if proceedings have been issued thereafter, so it does not relate to any proceedings that were issued before that date, even if you make a fresh application within proceedings, it doesn't count. There are certain circumstances which I've set out on the slide there, whereby the court will say it is mandatory for a qualified legal representative to be appointed to conduct the cross-examination on behalf of a party who is unrepresented. So what the court is trying to do is manage the difficult circumstances that cross-examination presents for litigants in person, both for that individual who is a litigant in person, as well as the individual witness who is being asked those questions. And the court effectively employs an independent representative to come in and conduct that cross-examination so as to assist the court. Previously, questions were put in writing, so if your case predates the 21st of July last year, a litigant in person is required to put their questions in writing. The judge will consider those and ask those, but the motion of the court process now is changing with the role of QLRs. You need to be alive to it. You need to be thinking about whether it's necessary in your cases and your fact-find hearings. There are different tests as to whether one is mandatory or discretionary, and as I say, I've detailed those in the slide. Lastly, pre-trial reviews are of real assistance of focusing minds, preparation, and to the court and parties knowing that the case is ready. And lastly, in terms of witness template, you may all roll your eyes when you hear me say witness template, and some wonder whether they're going to be kept to the times they're putting in that document. But the President has been really clear in his guidance at paragraph 23, no case should be timetabled to a fact-find hearing without a properly completed witness template. So those are absolutely essential now moving forward. I'm sorry it's been at such a canter, and we are going to take questions at the end after Liz has addressed you. Just in closing, my title was in respect of private law proceedings, but I give you a heads up if you haven't already seen that on the 5th of December, Mrs. Justice Leven handed down a judgment in public law proceedings, and it's called the case of Derbyshire CCAA and others, 2022 EWHC 3404. And in that case, she declined a fact-find hearing that was already listed a few days later for 9 days for a non-accidental injury to a baby concerning fractures, because a fact-find, in her judgment, was not necessary or proportionate, as it didn't impact the ultimate welfare outcome. So the approach both in private and public law proceedings is overlapping, and those 4 key topics or factors that I've said, relevance, proportionality, necessary and purpose, are all that the court will be focusing on. So I leave it there. Apologies for the canter. I'm very grateful to you all for listening, and I hand over now to Liz, who I can see has resolved her technical difficulties. Welcome, Liz.
Thank you. I hope you can all hear me. And very interesting talk, Emma. Thank you so much. I think we all learned a lot from that. My talk this morning is about the inherent jurisdiction of the court and when that might be something that we can activate. If a lay client came up to most of us at court and said, well, what about that inherent jurisdiction thing? Can't we use that? I think quite a lot of people would try and change the subject and really be very comfortable about discussing the court's inherent jurisdiction. And the aim I had today was to make you all aware that it is a power that we can use. It is something that's alive and well. And it's not the scary things only people in the High Court in London deal with. It's something that is available to everyone. So what is the inherent jurisdiction? And I should add, done some notes. I've not done the slides as Emma has done, but you will get a full handout. But I read you some of the definitions of the inherent jurisdiction to give you an idea of what we're looking at. So The inherent jurisdiction of the court, in effect, provides a safety net so that in the event there is no existing law available, where it's clear that a decision of the court is required, the court is able to make a decision. So it's a safety net, it's there, it gives the court that leverage. Involving the court's inherent jurisdiction may not be our everyday bread and butter, but cases involving the jurisdiction often involve controversial decisions. And that has led to a number of cases being reported and appealed and Supreme Court judgments. So we're lucky in that respect because we do have some good case law to look at. The exercise of the inherent jurisdiction, it's a broad doctrine. It's allowing the court to control its own process, control the procedure before it, and the power doesn't stem from any particular statute or legislation. And the concept of the inherent jurisdiction is that a higher court, so it's the High Court or above, has the jurisdiction to deal with almost any matter that comes before it. The ultimate aim is to ensure that justice is done. And so rather than it being one of these scary things that no one ever uses, it's supposed to be a safety net. It's supposed to be something that is available to us all, if in fact there isn't the law or the provision within statute or case law to enable it to happen any other way. Within the handout that you will get, as I say, after this lecture, I have attached the application form. If any of the application forms have moved on and someone wants to correct me, that's great. But I found the application form that I believe you use for an application to invoke the court's inherent jurisdiction, and it doesn't look a great deal different to an application for a Children Act order, you know, your normal Section 8 orders. So it made me feel that, you know, this is a jurisdiction that perhaps all of us can use more often if we need to. I had a look in researching for this talk, some of the history, because the inherent jurisdiction has been alive and well for a long time. And although I won't dwell on the history, I thought I'd just give you a little glimmer into some of it. There's a case called A, Local Authority against DL. It's 2012. It's a Court of Appeal decision. And it followed on from the Mental Capacity Act, which was in 2005. It made it very clear that the inherent jurisdiction has survived the Mental Capacity Act. I say that because a lot of cases invoking inherent jurisdiction involve people with mental capacity issues. And so this particular case said, doesn't matter, we've now got the 2005 Act, the inherent jurisdiction lives on. We had a case that was in 2012 called XCC and AA and another. And this was a case where it was, I think, what it was initially in the Court of Protection. And Parker J was concerned with the question of whether she had power under the Mental Capacity Act to make a declaration in respect of a child who suffered from a severe disability, which meant that she had little comprehension and she needed assistance with almost everything in everyday life. She was of Bangladeshi origin. She'd been married on an arranged marriage, and the matter had come to the attention of the local authority learning disability team, who were serious concerns about her welfare. In the face of strong opposition from her parents and AA, Parker made a number of declarations, Parker J. And what the court found was that the court could grant relief under the inherent jurisdiction in respect of a person who was incapacitated within the meaning of the Mental Capacity Act. She didn't have power under that act to make those declarations. She didn't have that power. So she went off on a tangent correctly and used the inherent jurisdiction to make the declaration that the marriage was in fact null and void. So that's where you're before a court already, you're in a different jurisdiction, you're under the Court of Protection. The judge is finding, I've not got the power under the act that I'm dealing with here to make the order I need to, but I can use the inherent jurisdiction as a High Court judge to give the right result. And that's what happened in that case. And just reading from the judgment, if I may, in short, it was held there was a statutory lacuna in the terms of the absence of power under the Mental Capacity Act. So a perfect example of where inherent jurisdiction may be useful. Now, recent case law, because that's something I'm sure that you will want to look at when considering if you have a case that could use these powers. Real thread of cases where people are vulnerable or people are young. Have a look at NY. It's a 2019 case, ladies and gentlemen, and it was an appeal, so you'll get the reference, but it goes all the way up to the Supreme Court, and it concerned a father's application for an order for the immediate return of his daughter from England and Wales to Israel. The court had found in the Court of Appeal stage that the Hague Convention test was not met. So the child could not be returned to Israel using the particular test that one would have to use under the Hague Convention. But the Court of Appeal had said that pursuant to its inherent jurisdiction, it could return the child to Israel, and that's what it did. So it came before the Supreme Court, who criticised the Court of Appeal. It doesn't happen that often, but this is one of those cases. It said, unlike the test under the Hague Convention, the test for the court to make a decision pursuant to the inherent jurisdiction is Section 1.1 of the Children Act. It's the best interests of the child. And the Supreme Court found the lower court, the Court of Appeal in this case, had failed to carry out a proper welfare checklist analysis to enable them to determine that the child's return to Israel under the inherent jurisdiction was correct. So an interesting case, one I advise or suggest you have a look at, because the Court of Appeal and then of course the Supreme Court deliberated over its inherent jurisdiction powers. So quite an interesting case to look at. Re A, this is in fact a slightly earlier case. This is the case of Re A Local Authority against S, 2015 High Court matter. An urgent application was made by a local authority for a secure accommodation order in relation to S under Section 25 of the Children Act, or if this was not applicable, under the inherent jurisdiction of the court. S was accommodated in a secure unit on a holding basis. When the matter came before the court, S asked that there be no extension of that secure accommodation order, promised to change her ways. This was a very, very troubled 17-year-old. The court determined that the criteria for a secure accommodation order under Section 25 of the Children Act was met, because the criteria were there. However, the judge went on to consider action under the inherent jurisdiction in the event that that analysis or his analysis was incorrect. And interestingly, the judge considered earlier dictum from Mr. Justice Mumby, where that judge described that it was quite clear that a judge has the power to direct that the child or adult in question shall be placed at and remain in a specified institution, such as a hospital, a residential unit, a care home, or a secure unit, involving a deprivation of liberty, with using the inherent jurisdiction powers. That case has probably been overtaken to some extent by a case that you're probably more aware of, which is Re T, Supreme Court again, 2021. The background to this case really involved highlighting the shortage of secure units that we have in England and Wales. There are innumerable children, particularly, who need to be placed in secure accommodation, and the court often find that those places are unavailable. And what Re T did was invoke the inherent jurisdiction. So rather than being an official secure accommodation placement, the court was able to broaden the areas of placement that are available using the inherent jurisdiction, so that where there are shortages, other means can be accepted and available. So Re T 2021 UK Supreme Court 35 is the case really to go to for that. The shortage has forced local authorities to seek orders from the High Court in its inherent jurisdiction, authorising alternative restrictive placements of children elsewhere than in an approved secure children's home. The case involved a 15-year-old girl and holding that the use of the inherent jurisdiction to authorise the deprivation of liberty was permissible. So the case flagged up the serious lack of resources in England and Wales to have approved secure accommodation. This lack of resources has forced the local authority to seek orders from the High Court under its inherent jurisdiction, authorising alternative restrictive placements. So that's the summary of it. I then wanted to touch on wardship, and really wardship and inherent jurisdiction all go hand in hand. When I started at the bar, wardship was very much in use. Of course, I started at the bar before the 1989 Children Act, and that act meant that wardship became very much redundant, albeit it is still alive and an option in certain circumstances. And when I was researching for the talk, I looked at children who have been removed from their parents or are. It is the duty of the court, under its inherent jurisdiction, to ensure that a child who is subject to proceedings is protected and properly taken care of. Wardship proceedings, ladies and gentlemen, are initiated to make a child a ward of court. If an order is made, the High Court effectively becomes the legal guardian for the child. And the child's welfare and their protection, and all significant decisions have to go through the court. As I've indicated, with the introduction of the Children Act 1989, the High Court's powers to make children wards were significantly reduced. Practice Direction 12D, and again, you will have this within the handout that you will receive. 12D makes it clear that wardship proceedings should not be commenced unless the issues cannot be resolved under the Children Act, and the local authority's ability to make an application is therefore cut down because of that. And the court the practice direction says leave will only be granted if the court is satisfied that the outcome could not be achieved by the making of any other order that the local authority could apply for, and there is reasonable cause to believe that if the court's inherent jurisdiction is not exercised with respect to the child, he or she is likely to suffer significant harm. So look at practice direction 12D because it sets a high bar for using the inherent jurisdiction, but it does mean that it's still there. It's not our everyday go-to, but it's nonetheless a go-to in the circumstances of some of the cases that I've had, as Emma put it, a counter through. Interestingly, I found in my research a case called Reed T. And for those of you, and I'm sure there are quite a lot of you who do a fair amount of care work, this case struck a chord with me. The court, find the judge's name in a minute, decided that there were two realistic options. One was to place the child with a paternal grandmother, and the second option was to place the child for adoption, and that was the care plan. And on a narrow balance of risk, the judge decided the best solution was for the child to be placed with the paternal grandmother. The local authority had not approved her as a foster carer, and so their care plan had been for adoption. The judge actually adjourned the case for the grandmother to be represented to panel. And at panel, the social workers, it says in the report, did not advance the court's assessment of the paternal grandmother. In other words, the court had assessed her the risk that she posed or didn't, and had decided that she was your best option. That wasn't put before the panel, and therefore, on the representation, she failed again. And the judge made a care and placement order for adoption. And it went to the Court of Appeal, who actually sent it back to a different judge for rehearing. I don't know what the result of that was. But what they said was that they flagged up inherent jurisdiction. And for me, that's very interesting. They were clearly thinking in the Court of Appeal, you know, perhaps that is the way to ensure when a local authority is not playing ball, aren't willing to amend their care plan, aren't willing to reassess a potential family member who the court, not anyone else, the court has assessed as a suitable carer for the child. Is this a case where the inherent jurisdiction might be invoked? The case doesn't answer the question, but it flags it up as a possible argument. So, ladies and gentlemen, practice direction 12D, have a look at it. It is the inherent jurisdiction, including wardship direction. It does read this. It supplements Family Proceeding Rule Part 12. Paragraph 1.1 of the practice direction states, the court may, in exercising its inherent jurisdiction, make any order or determine any issue in respect of a child unless limited by case law or statute. And practice direction 12D 1.3 makes it clear that the court's wardship jurisdiction is part of and not separate from the court's inherent jurisdiction. Finally, ladies and gentlemen, I think it's Form C66 that you need to use if you are going to launch an inherent jurisdiction application. And it looks very like one of those application forms you would make for a normal residence contact, call it what you will, child arrangement order. Now, I did see on the list of questions before I started my talk, well, how are you going to fund this? The answer is, I don't know. I have no idea whether public funding would be available. But what I do say is that most of these cases where you would be wanting to invoke the inherent jurisdiction are cases where you've got care proceedings ongoing. Not all of them. And so I would hope that on the back of a public funding certificate that you're using already, a further application could be made to launch your inherent jurisdiction application if it proves an appropriate application. But I will research that further, and if anyone else has the answer, of course, that would be great. So I hope that gives you an idea. I'll pass you back to Emma, who I know has some questions to deal with. Thank you, Emma.
Super talk, Liz. Thank you ever so much. Really informative and some really good tips from the case law too. We've had some questions in the Q&A boxes. Thank you to all of you who have submitted those. I have attempted to respond to some of you by way of written answers. There are a couple of themes that have cropped up just very briefly in respect of my presentation. The first of which is costs. If someone is publicly funded and the other side is privately funded, and the privately funded person manages to rebut the allegations, as it were, and therefore wants to claim costs, can they do that? In theory, yes. Anyone can make an application for costs. In terms of whether you're likely to succeed with that application, you will be well aware that in Children Act proceedings, it is rare for the court to make costs orders because the attempt is to not increase animosity amongst parties and focus on welfare of children. The other difficulty and complexity you have in relation to that scenario is costs would be coming out of the public purse because that person is publicly funded. And although it is in theory possible, and each case turns on its facts, so I can't give you specific advice for your specific cases, but I think it's unlikely that an application would succeed. And other people have drawn to my attention that post-fact-find hearing, if allegations are made, what if the respondent doesn't accept those allegations having been proven? Or indeed, if they do accept it, what do they do next? Because the commissioning for the DAPP, so the Domestic Abuse Perpetrators Programme, has been pulled from CAFCAS, so is no longer available. And as Liz said, in response to one of her questions, I don't know. We have a gap in resources and provision at the moment in that regard, and it's a real worry because the impact on children ultimately is vast. So it's likely that contact will have to be supervised in such circumstances, subject to the recommendations from CAFCAS or the local authority who are assisting the court. But that is a real difficulty for a number of cases at the moment, and it's not one that I know the answer to, I'm afraid. I think that broadly answers all the questions that we've been asked. Liz, did you spot any others that you would like to respond to?
I had three I spotted. One was, which form was I talking about in the application form? It is in the handout, but it's form C66 is the form I think we would use if we were launching an inherent jurisdiction application. I haven't personally launched one, and obviously solicitors are more able to know the correct form, but when I was Googling, it looked like form 66. I was also asked to give the name of the case I was quoting. It is in the handout, but it was the grandmother case, Re T 2018, EWCA Civ 650. So that was the case that I was referring to. And then I had another very helpful email saying that public funding might be available. So the person wished to remain anonymous, but nonetheless, thank you. It does look as if perhaps if you were to launch inherent jurisdiction applications, that funding may be available. So those were the questions I came back with, or the answers I came back with. Thank you, Emma.
Super, thank you. Well, it leaves and falls to me to close today's brunch. We are so grateful to each and every one of you that have taken the time out of your busy days to spend it with us this morning. We hope you have found our presentations informative and helpful. And if you have questions arising, please feel free to get in contact with Chambers. I'm sure Liz and I will both be happy to assist and respond wherever we are able.